Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya. In today's significant episode of Polity Primer, we are going to discuss yet another important Constitutional Amendment Act. The title of our today's discussion is the 44th Constitutional Amendment Act. In this discussion, we are firstly going to study about what is the 44th Constitutional Amendment and why is it so significant and important in the history of our constitutional amendments. Then we are also going to examine its historical background. Then we are also going to understand and study about the key constitutional changes that have been introduced via this 44th Constitutional Amendment Act in our Indian Constitution. And lastly, we are going to discuss some of the important questions from the perspective of your prelims examination. So if I talk about the 44th Constitutional Amendment Act, we all remember that the national emergency was in place in India from the years 1975 to the years 1977, and this period of 21 months is considered to be a very dark area in the history of our Indian Constitution. Many of the amendments were brought in this period, and the most controversial amendment that was brought was the 42nd Constitutional Amendment Act. And this 42nd Constitutional Amendment Act changed the whole face of our Indian Constitution. And there was a large public outcry over the enactment of this 42nd Constitutional Amendment Act, and the public was demanding to repeal the 42nd Constitutional Amendment Act. This 42nd Constitutional Amendment Act also led to the Congress party losing the majority in the general elections that were conducted in the year 1978. The Janata Party government came into power and it promised that yes, we'll undo the damage which has already been done by the 42nd Constitutional Amendment Act and we'll restore the original position of our Indian Constitution. So basically, the Constitution 44th Amendment Act passed in the year 1978 removed most of the aberrations and distortions introduced into the Constitution by the 42nd Amendment Act. Okay, so as I have said that yes, the Janata Party government won the elections on the promise that yes, we are going to restore the original Indian Constitution. Apart from this, the 44th Amendment also sought to amend a few other provisions of the Indian Constitution so as to achieve the following major objectives. So what are these objectives? Let us examine them one by one. So firstly, to ensure that the fundamental rights were not restricted or taken away by a transient majority in Parliament, it was necessary to provide adequate safeguards against the reoccurrence of such a contingency in the future and to ensure to the people themselves an effective voice in determining the form of government under which they were to live. So if you remember my previous discussion on the 42nd Constitutional Amendment Act, you might remember that it diluted the scope of fundamental rights to a very great extent. So this dilution of the fundamental rights were undone by the 44th Constitutional Amendment Act. Basically, it restored their position and said that no, the Parliament cannot dissolve or abrogate your fundamental rights on their whims and fancies, and they have to follow a due procedure of law. Then secondly, to take the controversial property right out of the category of fundamental rights and make it an ordinary legal right. So the right to property was a major obstacle in having any kind of social reforms. And it was a major focal point of tussle between the Honorable Supreme Court of India and the government at that point of time. So when we started analyzing the constitutional amendments one by one, we saw that yes, it was very difficult to conduct the social reforms because the right to property was a fundamental right. Whenever their right to property was violated, they went to the Supreme Court and the High Courts and they said that no, we are helpless, it is a fundamental right, and as it is a fundamental right, it is justiciable in nature. So basically, it was a major obstacle in the path of the conducting social reforms. Okay. Moving forward. To ensure that the power to proclaim an emergency under Article 352, which virtually has the effect of amending the constitution by converting it to a unitary state and suspending the right of the citizen to enforce their fundamental rights, was used properly after due consideration and deliberation, and was not misused for personal or partisan ends. So basically, all of us remember that yes, emergency provisions were made absolute by the 42nd Amendment. That means the decision of the Parliament to proclaim an emergency could not be questioned. The satisfaction of the President of India in proclaiming emergency not only in the whole country but also in the part of a country was final and conclusive in nature, and in fact the Honorable Supreme Court of India also lost its jurisdiction in this regard. Lost its jurisdiction in this regard. That means the proclamation of emergency was outside the purview of judicial review, and this was very considered not to be good. It was considered to be very controversial in the history of our Indian Constitution, and that is why the 44th Constitutional Amendment placed certain safeguards while proclaiming the emergency in our country. Fourthly, to ensure that the fundamental and basic features of the Constitution were not lightly interfered with by the Parliament in exercise of its power of constitutional amendment under Article 368 of our Indian Constitution. So basically, we all know that the ruling Parliament at that point of time was not really happy with the enforcement or the evolution of the doctrine of basic structure. But the 44th Constitutional Amendment Act said that no, you are not the Constituent Assembly, you cannot write the Constitution, or you cannot rewrite the Constitution by making n number of amendments in our Indian Constitution by utilizing your power under Article 368, and you cannot alter or change the basic features of our Indian Constitution. So this was ensured by the 44th Constitutional Amendment Act. Moving forward, let us analyze the historical background. So as I have explained to you in brief that yes, there was a huge public outcry over the enactment of the 42nd Constitutional Amendment Act. The public was saying that yes, now repeal this Amendment Act. So basically, the Congress party lost the general elections. The Janata Party came into power and it promised that yes, we are now going to undo the damage which was already done by the 42nd Constitutional Amendment Act. So basically, the Janata government enacted the 44th Amendment Act to the Constitution in order to repeal some of the amendments made by the 42nd Constitutional Amendment Act of 1976. It changed the Indian Constitution on a large scale to make the Indian government more democratic in nature. And why so? Because the 42nd Amendment Act established the supremacy of the Parliament. It made the character of our Indian Constitution more unitary in nature. But who is actually supreme in India? The people of India, because we are voting and we are electing our representatives to represent us on the floor of the houses of the Parliament. So basically, it changed the Indian Constitution to make India a truly democratic country. Moving forward, let us analyze the key constitutional changes that have been brought through the 44th Constitutional Amendment Act in our Indian Constitution. So the first change is in respect with Parliament and state legislatures. You all know that they were made very powerful. Especially the central government, because the 42nd Constitutional Amendment Act established the supremacy of the central government. Okay, and they were made so supreme that they could act as an unitary state. unitary government or as a unitary state. Okay. But the 44th constitutional amendment did away with all of this. Okay. So basically it restored the term of Lok Sabha to 5 years from 6 years. Okay. So basically the 42nd Amendment Act extended the term of the Lok Sabha to 6 years. But it was put into its original position by the 44th Amendment. Then the status quo was also restored in respect of the quorum in the houses of the parliament as well as the state legislatures. So basically the 42nd Constitutional Amendment Act made quorum as a matter of just a routine procedure. It did not pay heed to the mandatory requirement of the quorum. But this was all undone by the 44th Constitutional Amendment Act, and now quorum was made mandatory and it was restored to its original position. Moving forward, the 42nd Amendment had amended Article 103 as regards the procedure to decide the question of disqualification of a member of parliament. Basically, a member of parliament, especially the prime minister, could not be disqualified on the ground that he was disqualified under any law. Disqualified under any law that was in force before the enactment of the 42nd Constitutional Amendment Act. So basically it put a major restriction on the disqualification of member of parliaments as well as the prime minister. So this was restored by the 44th Constitutional Amendment Act, and now if a MP or the prime minister himself or herself are disqualified under any law that was in force for the time being, they would be considered disqualified from holding elections. Henceforth, the question of the disqualification of a member of a House of Parliament is to be decided by the President in accordance with the opinion of the Election Commission, and same is the case with the members of state legislative assemblies. The governor was empowered to decide on their disqualification by taking an opinion of the Election Commission of India. Moving forward, Article 102, Clause 1, Subclause A, regarding office of profit as it stood originally prior to the 42nd Constitutional Amendment Act has also been restored. So basically the Supreme Court regained its jurisdiction to decide which offices are considered to be office of profit. Office of profit by exercising its power of judicial review. Okay. So basically the courts regained their power to examine any kind of office to determine whether it is an office of profit by the virtue of 44th Constitutional Amendment Act. Articles 105 and Article 194 were also amended to restore the parliamentary privileges. Moving forward to the President of India and the governors of states. So basically 44th Amendment Act empowered the President to send back once the advice of the cabinet for reconsideration. We all remember that the 42nd Constitutional Amendment Act inserted Article 74 Clause 1 in our Indian Constitution, which made the President bound by the aid and advice, of the Council of Ministers. Okay, so this 44th Constitutional Amendment Act relaxed the rigors of this article and said that although the President is bound by the aid and advice of the Council of Ministers, but he is empowered to send the advice once for reconsideration. But if he is receiving the same advice again, then he is bound to follow the advice. Okay. The 38th Constitutional Amendment had added Clause 4 to Article 123 and 213 so as to make the satisfaction of the President or the Governor to issue ordinances final and conclusive. The 44th Constitutional Amendment Act also did away with this thing. Okay, so basically it deleted Article 123 Clause 4, which means now the courts have jurisdiction to decide under judicial review the promulgation of or the validity of the ordinances if they are prima facie mala-fide in nature. So basically this also gave the courts their original jurisdiction back on deciding whether it was constitutional for the president or the governor to promulgate an ordinance or not. Moving forward, with reference to the high courts and the Supreme Courts, so as we all know, there was a constant tussle between the Supreme Court of India and the high courts of states and the government of India at that point of time. And the basic purpose of the 42nd Constitutional Amendment Act was to curtail the jurisdiction of the Supreme Court of India and the high courts of states, to avoid any kind of confrontation with the judiciary and to maintain the supremacy of the central government over the executive and the judiciary. So the Constitutional 42nd Amendment introduced Article 139 Clause A, allowing the Supreme Court to withdraw cases from the high courts under certain circumstances, initially upon the Attorney General application. But the 44th Amendment continued these provisions, but with modifications, allowing the Supreme Court to withdraw cases either suo motu or upon a party's application. So basically the Supreme Court was now free to withdraw the cases from high courts and decide them itself, and this was done for the purpose to reduce the pendency of cases. Okay. The 44th Amendment also introduced Article 134 Clause A, changing procedures for high courts, certification for Supreme Court appeal. So what does this Article 134 Clause A states? That if there is a substantial question of law is involved in a case and if it needs interpretation or the interference of the Honorable Supreme Court of India, then High Court will certify that yes, you can appeal this case in the Honorable Supreme Court of India. So the former Article 132 Clause 2 was repealed by the 44th Amendment, allowing the Supreme Court to consider granting special relief to appeal under Article 136 if the High Court refused the certification. In fact, the 44th Constitutional Amendment Act also restored the writ jurisdiction of the High Court under Article 226, and basically it also reintroduced or restored the power of superintendence of High Court, power of superintendence of High Court over lower courts and tribunals in the country under Article 227. So basically the writ jurisdiction and the power of the superintendence of high courts over the lower judiciary as well as the administrative tribunals in the country was finally restored by the 44th Constitutional Amendment Act. Moving forward, the 42nd Amendment provision for appointing distinguished jurists as High Court judges was also repealed by the 44th Amendment, and the 42nd Amendment restricted High Court's original jurisdiction regarding revenue matters under Article 225, which the 44th Amendment removed, restoring the previous position. So basically, it gave the Supreme Court and High Court back their original jurisdiction, which was curtailed, back their original jurisdictions. So finally, the original jurisdiction of the Honorable Supreme Court of India and the High Courts of the state was to an extent restored by the 44th Constitutional Amendment Act. Moving forward, to the fundamental rights. So the most important thing that was done by the 44th Constitutional Amendment Act was the removal of right to property as a fundamental right. So basically it removed the right to property from the category of fundamental rights and made it as a right which can be regulated by ordinary law. And let me know in the comment box below whether right to property is a constitutional right in India or it is a legal right in India. With a view to achieve this objective, the following changes were introduced in the Constitution. Article 19 Clause 1 subclause F was deleted, which was talking about right to property as a fundamental right. Article 31 was also omitted. Article 31 Clause 1 became Article 300A, saying that no person shall be deprived of his property save by authority of law. So basically, if the parliament has the authority of law, it could deprive you of your property. The safeguard contained in Article 31 Clause 2 relating to acquisition of property of an educational institution established and administered by a minority is now sought to be incorporated in Article 30 of our Indian Constitution. Thus, a new clause 1A has been added after Article 30 Clause 1. So basically, the crux is right to property was removed as a fundamental right. Moving forward to the directive principles of state policy. So a new directive principle was inserted by adding a new clause to Article 38 to the effect that the states shall strive to minimize inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities not only amongst individuals but groups of people residing in different areas or engaged in different vocations, because India is a welfare state. India is a predominantly welfare state. And there was a huge amount of inequality prevalent during those times, and that is why this directive principles of state policy was inserted under Article 38 to remove the inequality in the society. Moving forward to the emergency provisions, and this is important because the emergency provisions were made absolute in nature, were institutionalized by the 42nd Constitutional Amendment Act, and that is why the 44th Constitutional Amendment Act wanted to add in certain safeguards before the proclamation of national emergency or the president's rule in a state is done. Okay. So the 44th Amendment Act replaced the term internal disturbance, which was a major point of issue while the proclamation of emergency was done, okay, with armed rebellion in respect of national emergency. Okay. The 44th Amendment provided that the president can declare a national emergency only on the written recommendation of the cabinet, and this was done to ensure that the Prime Minister cannot be the sole authority to decide that yes, now proclaim an emergency, which had happened before. Okay. So now the written recommendation of the cabinet was required for the president to declare a national emergency. Moving forward, the 44th Amendment Act made certain procedural safeguards with respect to a national emergency and president's rule. Now, if the Lok Sabha thinks that yes, the proclamation of emergency should be removed, it can call a special sitting of the House and can vote to remove the national emergency. Similarly, the president's rule has to be reviewed after 6 months. Previously, the period was 1 year. Now it has been reduced to 6 months. After 6 months, if the elections happen or it is decided that yes, now the president's rule is not required, then it has to be reviewed by within a period of 6 months. Okay. 44th Amendment Act provided that the fundamental rights guaranteed by Articles 20 and 21 cannot be suspended during the national emergency, because the government is not empowered to harass the citizens. The government is not empowered to take away the right to life of the citizens even when the national emergency is in force. So these were some of the important procedural safeguards that were introduced in the emergency provisions by the 44th Constitutional Amendment Act. Moving forward, the 44th Amendment also added a new Article 361 Clause A to the Constitution so as to ensure that no one was held liable to any civil or criminal proceedings in a court in respect of the publication in a newspaper of a substantially true report of the proceedings of either house of the parliament or a state legislature, unless the publication was proved to have been made with malice. So basically it also restored the freedom of press. Restored the freedom of press, which was curtailed to a very great extent by the 42nd Constitutional Amendment Act. This immunity, however, would not apply to the publication of any report of the secret proceedings of a house. And with this, we come to a conclusion of our today's discussion. We have discussed in detail what led to the enactment of the 44th Constitutional Amendment. We have also seen the key constitutional changes that were introduced in our Indian Constitution by way of the 44th Constitutional Amendment Act. And we also saw that yes, though many of the provisions of the 42nd Constitutional Amendment Act were retained by the 44th Amendment Act, but predominantly it reversed the Indian Constitution in its original form. Okay, so this was the major contribution of the 44th Constitutional Amendment Act to our Indian Constitution. Now let us discuss the previous practice question which I asked in my previous session. So the question was, which constitutional amendment deprived the parliament of its special power to make laws to deal with anti-national activities? So your options were option A, 42nd Constitutional Amendment, your option B was 43rd Constitutional Amendment, your option C was 44th Constitutional Amendment, and your option D was none of the above. So the correct answer for this question is option B, 43rd Constitutional Amendment. Now let us discuss the practice questions from our today's session. So the question is, consider the following statements. Your statement number 1 is, right to property as a fundamental rights was removed by the 44th Constitutional Amendment Act. Your statement number 2 is, the 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. Which of these statements given above is our correct? Options are, option A is 1 only, option B is 2 only, option 3 is both 1 and 2, and option D is neither 1 nor 2. So the correct answer for this question is going to be option A, option 1 only. Statement 1 is correct and the statement 2 is incorrect. Moving forward to the last question of our today's discussion. So the question is, which of the following changes was not introduced by the 44th Amendment Act of India? Kindly remember this word not here, because you do these silly mistakes in your examinations as well. So kindly read the question carefully before attempting it. So option A is empowering the Supreme Court to withdraw cases from the High Courts either suo motu or upon a party's application. Option B, repealing the provision for appointing distinguished juries as High Court judges. C, curtailing the High Court's original jurisdiction regarding revenue matters. And option D, introducing Article 139A, allowing the Supreme Court to withdraw cases from High Courts upon the Attorney General's application. So this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.